You can be smart and still do stupid things. And this particular mistake, I see it constantly. Smart people, good parents, people who just wanted to make their life easier for their kids. And they did it with the best intentions in the world. They put their kid's name on the deed. Done. Simple. No probate, no courts, no hassle, right? Wrong. So wrong. Here's a hypothetical I want you to sit with for a minute. Imagine your daughter is driving home from work one Tuesday afternoon. Fender bender. Nobody hurt. Seems like nothing. But 3 months later, she gets served with a lawsuit for $250,000. Could happen to anyone. And here's where it gets ugly for you. Because you put her name on your deed last year to keep things simple, her name is on your house. She owns half of it legally. And since she lives in her own apartment across town, Florida's Homestead protection does not cover her half, not one penny of it. That creditor can now file what's called a partition lawsuit. They can ask a judge to force the sale of your entire house. Your house, the one you live in, just to get their hands on her half of the equity. You get your half of the money and you lose your roof. You worked 30 years to build that security. And in about 30 seconds of good intentions, you handed a stranger a seat at your kitchen table. That is the early title mess. It's the single most common mistake I see in Florida. And today we're going to break down exactly why it happens, what it costs, and what you should be doing instead. I'm Tom McNamara, Florida Real Estate Insider. If you're new here, hit subscribe and ring that bell. This is video 2 in our series on the 6 ways good people accidentally wreck their kids' inheritance. Let's get into it. As always, I'm not your attorney, and this is not legal advice. Everything I tell you today is the beginning of your education. Qualified real estate attorney, licensed in your state, is the end of it. We good? Let's go. Let's start with the tax problem. Because even if your daughter never gets in that fender bender, even if nobody ever sues anybody, putting her name on that deed is still going to cost her money, possibly a lot. Here's why. When you bought your home, let's say in 1985, $150,000, that's your basis. That's what the IRS thinks you paid for it. Now that the house is worth $750,000, that's $600,000 in growth. And when you pass away and your child inherits that house properly, something called a stepped up basis kicks in. Her basis resets to $750,000, the value at the time she inherited it. She sells it for $750,000 and her tax bill, $0. But the moment you put her name on that deed today, right now, you just gifted her your 1985 price tag, your $150,000 basis. When she eventually sells that house, the IRS is going to want a conversation about $600,000 in gains. We're talking $90,000 to $120,000 in capital gains taxes. You were trying to help her avoid probate. You just handed her a 6-figure tax bill instead. Stop helping your kids into a tax bracket they can't afford. Always consult a state-specific real estate attorney before you touch that deed. Now, let's get back to that partition lawsuit because I want to make sure this lands. Florida's Homestead law is one of the strongest creditor protections in the country. It is genuinely powerful. But here's the catch. It only protects the person who actually lives in the home as their primary residence. The moment you add your daughter to that deed, you've split the shield. Your half is protected. Her half is completely exposed. And it's not just lawsuits. I want you to hear from my friend, Joe Seagull. Joe is a Florida real estate attorney I've worked with for over a decade. Here's how he explains what happens when you put your kid's name on your deed.
Is your son married? Yes. How much do you like his wife?
Uh-huh.
Oh,
there you go.
We don't really get along well. Okay, well, you give him half. She now has an interest in his half, even though her name may not be there. if they get divorced, if he has a crash, if he signs a contract and it goes sideways, if he personally guarantees a loan, it goes sideways. If he owns a rental property and it's got a trampoline, somebody gets injured, his half of that house that you own is now dragged into it.
Exactly. Yeah.
And even if it's your homestead, your half may be safe, but you've just given away half to whoever he's getting in trouble with. So again, we push the enhanced life estate deed or
Enhanced life
Ladybird
estate,
deed.
right.
Yeah.
And that is exactly right. It doesn't have to be a car accident. It doesn't have to be a lawsuit. If she goes through a divorce, her spouse may have claim on your equity. If she has a tax lien, the IRS just became your co-owner. Any judgment against her is now a problem for your house. This is not a small risk. This is a wide open door. Always consult a state-specific real estate attorney before you add anyone's name to your deed. So here's a question I always get at this point. Tom, I just want to avoid probate. I don't want my kids stuck in a courtroom for 19 months like that family you talked about last week. How do I do that without all this mess? Great question. And in Florida, we actually have a really elegant answer. It's called a Ladybird deed. The technical name is an enhanced life estate deed, but nobody really calls it that. Here's how it works in plain English. You keep total control of your home while you're alive. You can sell it, refinance it, change your mind completely without asking your kids' permission. It's still your house, but when you pass, it transfers to them automatically. No probate, no judge, no waiting. And because they didn't legally own it while you were alive, their creditors can't touch it. The stepped up basis is preserved. The tax bill stays at zero. It is, in my opinion, one of the most underused tools in Florida estate planning, and most people have never heard of it. Talk to a Florida real estate attorney about whether a Ladybird deed or a trust is the right move for your situation, but please stop using quitclaim deeds at the kitchen table. Here's where we are. The early title mess is a self-inflicted wound, and the painful part is it almost always comes from a good place. Parents trying to protect their kids, trying to keep things simple, trying to avoid the courthouse. But simple is not the same as smart, and a quitclaim deed is not a good plan. Here's what I want you to do right now. If your child's name is already on your deed, find out. Pull it up. Know what you're working with. If it's already done, a good attorney may be able to help you restructure it before it becomes a problem. If you're thinking about doing it, stop. Call an attorney first. Have that conversation before you sign anything. And if you need to know what your home is actually worth today so you can calculate that tax exposure and take real numbers into that attorney meeting, reach out to me. The link is in the description. Next week, we're tackling mistake number 2, the $20 legal form disaster. I'm going to show you exactly how one word, one missing phrase, one notarization done slightly wrong for your county can cloud a title so badly that your kids can't sell the house for years. It happens more than you think. This has been the Florida Real Estate Insider. I'm still Tom McNamara. See you in the next one.